Oh, that's true. Yes.
My lord, it's a simple point of law, my lord. If your lordship kindly sees,
রিভিউটা বার করে দিন রিভিউটা আলাদা করে দিন কন্টেন্ট আলাদা থ্যাংক ইউ ইয়েস
your lordship has passed the order
Yes.
17/4/2023
Mhm.
based on the fact, lordship kindly sees lordship's order. It is submitted by placing reliance on the provisions of the West Bengal Lifts, Escalators and Travelators Act. The same does not have any provision to make an exception for home lifts to be entitled to flout the rules as stipulated under the Act. My lord, here I'll just pause, lordship. Lordship will kindly take up the Act itself. The West Bengal Lifts and Travelators Rule.
Got a
Travelators
copy of the act? Anybody got a copy of the act?
My lord, I have quoted the sections in my application.
You have quoted this section. Let us see that.
Yes, my lord, I'll just point it out.
Yes,
I'll just point it out. Kindly give me a second. My lord, if lordship sees page 7, page 8. Page 8, my lord,
Yes.
the section 2 says nothing in this act shall apply to installation and working of any lift, escalator or travelator in any mine within the meaning of Mines Act, to which the provisions of the Factories Act 1948 in the premises of central government or its undertakings, in the premises owned by owned or controlled by the Public Works Department of the Government of West Bengal, in any premises or any class or subclass of elevating device as the state government made by notification exempt. Now, under that leaving provision, the rules being the West Bengal lift escalator and travelator rules 2020 were applied. But it kindly sees, it's a previous page I have quoted the rule. I also have a copy of the rule if your lordship wishes to see. I'll just provide the rules to your lordship. This is the rule, your lordship.
Yes.
The rules, my lord, kindly sees rule 80 in the rules. My lord will kindly see lifts, escalators and travelators not covered under these rules. Home lifts, single phase, lift, escalator, travelator installations owned by the central government or central government undertakings, lifts installations owned by state government or by PWD or installations of any other state government within the state of West Bengal are not covered by this rule.
This was dealt with either in this matter or different matter.
My lord, can you see
It's not the rules, but the act applies.
My lord, the act gives the power to the state government to exempt the application of the act under section 2.
No, but the difficulty is if it does not say that this is exempted from the rule, exempted from the rule is entirely different from exempt, not covered by this rule, may not be covered by the rule. If it is not covered by the rule, then it cannot be under the exemption from the act because the act says rules may exempt from this act
Yes,
any
my lord.
particular type.
My lord,
If
here,
it is exempted from the rule itself,
my lord,
then it
the
cannot be
rules-
exempted under the act.
My lord, I admit your lordship may not be the perfectly drafted provision.
Perfectly drafted provision in
But
a
My
rule.
lord, but my lord, kindly sees not covered under these rules. Now, what is made applicable under the rules will be under the act. The act itself says the state government may choose to exempt in any premise or class or subclass or
You
elevating
should have preferred an
devices.
appeal. This is arguable. I mean, there's a possible interpretation. I mean, this is not an error apparent on the face of the because arguments are necessary.
My lord,
I
because
need not go into
home lifts-
facts.
I'll just say this much. If it is not covered under this rule, my lord, then the rules, if you see, lordship, is an extensive guide as to what the chief electoral inspector has to or has not to do
Okay.
under the act. Now, if it is not covered under these rules, my lord, then how will the act apply to these devices?
Was this dealt with at all in the order?
Yes, my lord. May I just point out, my lord? 24th of February 2024, the first order. Not, my lord, the final order. The first order, my lord, it has been dealt with.
(23rd of February).
23rd of February.
Which paragraph? 23rd of February is passed in the contempt itself.
My lord, 2023, the writ petition, my lord. The order of the writ.
No, the order under contempt, which is under contempt.
No,
that,
my lord. The writ petition order. 2020. Free order, my lord. The writ petition, my lord, that is 4013. That order, my lord. From where, my lord, the contempt has, my lord.
have you got a copy of that order?
Writ
My lord,
petition and
in any event, my lord, allow me to complete, my lord. Yes, there is it's an arguable fact whether lifts come under this category or not. Lordship may say that this is not clear in that instance.
Hmm.
But my lord kindly goes on to see your lordship's order at page 3. Page 3 of your lordship's order, which is the subject matter of the review.
Yes.
My lord, the costs have been ordered based on attempt of the chief electrical inspector is palpably illegal. My lord, the thing is, the palpable illegalities is not
It's
a
not so palpable, you're saying.
I'm saying
If it's arguable, it's not
a deliberate stance taken by the chief electrical inspector that I'm not going to exercise my power. The chief electrical inspector is under the bona fide impression that he does not have the power to supervise home lifts installation. Therefore, my lord, lordship has interpreted that there is no exemption for home lifts, and therefore attempt by the chief electrical inspector to not intervene in this matter is illegal.
Yes.
Therefore, your
The
lordship has
contempt is only regarding the costs.
Yes, my lord. That's it. That's it. We have no other interest in the matter.
Well, so far as the
But whether there is a lift, whether
The
there
other compliances have been made.
yes, that excellent. The other compliances, my lord, so far as, my lord, the demolition of the structure, my lord, a review, my lord, of appeal was preferred, my lord, by the private respondents, my lord, before the Chief Justice, my lord. The Honorable Chief Justice, my lord, directed the lift be demolished within 3 days.
What about the cost?
Cost, my lord,
cost
that
to
part is,
compare.
my lord.
You have not preferred any appeal.
I preferred an appeal. The Chief Justice directed me to come before your lordships. I was going to press this point before the Chief Justice only. Chief Justice said, first bring this to the attention of the single judge. My lord, my only submission is there is no illegality on the part of the chief electoral inspector. If your lordship feels that there is an ambiguity in the law, that's a different matter.
No, that's not a different. That goes in your favor.
Yes.
If there is ambiguity, it cannot be palpable.
Exactly, my lord. That's my entire point. It's a bona fide exercise of powers by the chief.
So let me see what are my findings.
So what are the demolition part of the deed by the HMC, my lord?
Yes, yes.
That part,
That you have done.
that part, my lord, they have dismantled and
Yes, that they have done. Now let me see from my order whether there is any justification for that cost.
My lord, kindly see from the beginning.
Yes.
It is submitted, that portion I read, it is submitted, there is no exemption for, same does not have any provision to make an exception for home lifts. It is seen even from a cursory perusal of the said statute that the petitioner is absolutely justified in so submitting, since no exception has been carved out for home lifts for the purpose of flouting the rules framed under this act. My lord, kindly see, rules framed under this act. Therefore, if it is not covered by the rules, the exception for home lifts means that it's not covered by the rules of the act. It is clear from the order.
If it's not covered by the rules, Mr. Akku, there is no exemption also.
If it is not covered by the rules, my lord, that's the thing.
The rules, it has to be covered by the rules under the exceptions carved out in the rules. If it is not covered by the rules,
exceptions given otherwise. There is no other exceptions given in the under the rules to exempt any class or not. This is the only rule which pertains to exempting any kind of devices. In fact, if your lordship sees, they have gone on to further exempt a category of vehicles which has already been exempted by the main act because they're covering every base there. Bad. I mean, I'm not to comment on the drafting of the draftsmanship of the rules, but according to me, it is poorly drafted. It should have been made absolutely clear that this is exempted as per the provisions in section 2. But my lord, the point is, the lordship has taken exception to that the chief electrical inspector devised an exception for home lifts to save the skin of the respondent developers who have unlawfully constructed.
but there is no basis for that finding, you are saying, in the order.
Well, that is the thing. The lordship has held that since there is no exception for home lifts, the fact that the chief electrical inspector has not intervened is to save the skin of the respondent. But this is not the case, lordship. The chief electrical inspector has all along operated under the presumption that home lifts is exempted under the purview of the act, under the rules. that the home lifts are not governed under the power of the chief electrical inspector. under the
Let me
rules.
hear them. Yes, what do you say?
My lord, this provision has already.
Two things, two questions I'll put. Two grounds for free here, which are valid grounds. I mean, apparently, one is that if there is even a little scope of interpretation, it's not a palpable violation. One. Secondly, I have found in that order that it is clear that the respondent developers, in tandem with the chief electrical inspector, have been seeking to deliberately flout. Now, this finding in my order is not backed by reasons or sufficient materials to show that the chief inspector was in tandem. So, if that be so, why should 50,000 costs be imposed on the chief electrical inspector? Why should that order not be perverse? That direction not be perverse? My own direction.
My lord, may I just, my lord, point out, my lord, the definition. My lord, Act Section 2 and Section 3 of
No,
the
it's
Act.
arguable. I'm not saying that it
My lord,
is. My
mainly,
interpretation is correct.
lord,
I cannot say in review.
My lord, I was there, my lord, when the writ petition was taken up, my lord. My lord, the point was, my lord, the conduct was, my lord, considered also. My lord, they failed
I
to
was apparently I went overboard.
my lord, they failed to appear before your lordship on numerous
That's the
occasions.
problem, man. That is the
No, but there were other problems also in the representation. Also, not only poor draftsmanship.
My lord, that's my lord, all the
So because
factors. My lord,
that finds reflection in my order. I don't remember that day, but in my order, from my order, I get that. The
My
spirit.
lord, the point is,
so far
it
as
should
the
have
legal points
appeared.
goes,
So
my
they
lord,
are right on this
So far-
because the review application, if it is even because an electrical inspector is not a legal person,
my lord.
now there
It's
is
a government person,
scope
my lord.
of doubt.
It's a government person.
Government person, who told you government person is a
Yes.
legal person?
No, no, my lord, not legal, my lord, but my lord,
Not
holding a,
legal in the sense that he is an illegal person. I mean, he's a person
my
definitely,
lord, not my lord,
but not a
person with, my
law
lord, vast
knowing
legal
person.
knowledge.
Not some electrical inspector. If he may think that he knows law, but he's not supposed to.
My lord, other
It's not a
factors.
part of his job profile.
My lord, so far as the my lord, cost part
50,000
goes,
is a bit too harsh.
so far as the cost part goes, my lord, other factors were considered, my lord, some of which I can,
Considered but not reflected in my. If it is not reflected
some
in
of
the
which
order,
can be reflected, some of which cannot be reflected.
no. If this was passed by a district judge, I would have set it aside because it's perverse. Why not the same rule should apply to the High Court judge also? That's me.
And my lord, so far as the legal provisions goes, my lord, Section 2.
It's perverse.
Section 2 and Section 3, my lord, never defines home
Its
lift.
tandem portion is perverse, and that is the premise of the cost.
My lord, I'll leave it to your lordship, my lord.
However,
But my lord, may I only, my lord, point out, my lord, repeated, my lord, service after that not appearing, my lord, something has to be, my lord, put on record, my lord, regarding that.
yes, the culprit is actually you. You are too convincing on me on the previous occasion that he is in tandem.
My lord,
No, but you may have a point there, but that's not substantiated from the materials. We have to go by the materials
my
only.
lord, the substantiated means, my lord,
This is an error apparent on the face of.
whatever your lordship, my lord.
Learned counsel for the review applicant contends that the review is confined to the imposition of costs of rupees 50,000 on the respondent number 3 in the writ petition, that is the chief electrical inspector. Push up. Learned counsel for the applicant argues that in terms of Rule 80 of the West Bengal lift, escalator and travelator rules, 2022, home lifts within bracket single phase bracket closed has been stipulated not to be covered by the rule. Full stop. It is submitted that although the language could have been happier, the definite impression created by such provision is that home lifts are exempted from the purview of the Act. Full stop. It is pointed out by learned counsel for the review applicant that the relevant section
Your lordship is taking
Uh,
up Section 2.
section 2, where is
Section
that
2, my lord, I've
quoted?
got the copy of the Act. My lord, kindly
I'll just
please, my lord, only, my lord, my point was, my lord, nothing is defined as to what is home lift, and that is exempted from home lifts.
কোনখানটা ছাড়লাম? That is section 2 provides that section 2 of the West Bengal lifts, escalators and travelators Act, 2019 provides that nothing in the Act shall apply to installation and working of any lift, escalator or travelator as in terms as provided therein. Full stop. In clause Roman 5 within bracket thereof, comma, it is stipulated that nothing in the act shall apply to any premises, nothing in the act shall apply in any premises or any class or sub hyphen class of elevating device as the state government may by notification exempt. Push-up, it is contended that the said section read in conjunction with Rule 80 of the 2022 rules clearly shows that home lifts are actually exempted from the purview of the Act, and thus, comma, the premise of the order under review was bad. Push-up, next para. It is further contended that even if there was any scope of interpretation, comma, it was not expected that the chief electrical inspector, comma, not being a person supposed to know the law, comma, could have interpreted it beyond doubt, and as such, comma, the finding within bracket palpable double inverted close in the order under review, so far as it applies to the chief electrical inspector, comma, could not have been valid. Moreover, comma, the complicity of the chief electrical inspector is not borne out from the materials discussed in the order under review to saddle the said official with such huge costs. Full stop, next para. Learned counsel for the writ petitioner stroke respondent in the review application argues that since home lift double inverted মধ্যে is not defined in the parent act at all, and as rule 80 stipulates that home lifts within bracket single phase are excluded from the provisions of the rule and not the act, comma, the interpretation sought to be lent to the said provision by the review applicant is incorrect. Full stop. That apart, comma, the complicity of the chief electrical inspector, comma, it is argued, comma, is evident from the records annexed to the writ petition itself. Full stop, next para. The scope of review under the provisions of Order 47 of the Code of Civil Procedure and the parameters thereof apply to a review in connection with a writ petition as well. Full stop. The only yardstick in the said provisions applicable to the present case could be within double inverted error apparent on the face of record double inverted close, comma, since there has been no discovery of new matter. Full stop, next para. There are two factors where the review applicant is justified in his arguments. Full stop. The first is that the premise of imposition of costs in the order under review was that the attempt of the chief electrical inspector was held to be within double inverted palpably illegal double inverted close. Full stop, next para. However, comma, the review applicant is justified in arguing that although the the interpretation of rule 80 accepted by this court was one of the plausible interpretations, comma, even if there is a subtle SUBTLE, subtle ambiguity in the provision, comma, it is not for the electrical inspector to be expected to interpret the same in consonance with the judgment of this court. Push up. The very ambiguity or scope of interpretation in Rule 80 justifies the stand taken by the chief electrical inspector that he was not certain as to the actual interpretation of the said provision and could have interpreted it in the manner as done by proceeding on the premise that home lifts are exempted from the act. Full stop. Next para. Thus, comma, the finding of palpable illegality in the order under review, comma, which was one of the premises of imposition of costs, comma, is invalid. Full stop. The other premise was that the chief electrical inspector intended to aid and perpetuate the illegality perpetrated by the developers respondents. Full stop. Next para. It has been observed by this court in the order under review that the chief inspector acted in tandem with the perpetrators of the wrong. Full stop. Next para. However, comma, a careful perusal of the order under review does not reflect any substantial premise for such finding of complicity between the chief electrical inspector and the perpetrator of the wrong. Full stop. Thus, comma, the second basis of imposition of costs as finds place in the order dated April 17, 2023 in WPA 4013 of 2023 is also perverse. Full stop. In view of my finding in the said, in view of my such finding being perverse, comma, the very premise of imposition of costs on the chief electrical inspectors, comma, being not borne out by the reasoning in the order under review, comma, is required to be set aside. Full stop. Accordingly, RVW কত
136 of 2024.
well yes RVW যেটা আছে
136, my lord.
right
136.
136 of 2024 is allowed to the extent that the imposition of cost of rupees 50,000 on the chief electrical inspector and the observations to the effect that the chief electrical inspector acted in palpable illegality and intended to aid and perpetuate the illegality perpetrated by the developer respondents in tandem with them are set aside. Full stop. The order under review stands modified accordingly. No arrest to cost, urgent certified copies. Next,
much-
CPN, then the CPN does.
CPN, my lord, no more, my lord.
CPN such and such is now taken up for hearing. Full stop. In view of the above order passed in the review application, comma, setting aside the cost imposed on the chief electrical inspector stroke alleged contemptor, comma, the contempt application loses its cause of action. Full stop. Accordingly, comma, CPAN 1476 of 2023 also stands disposed of in the light of the above observations.
Lordship will, my lord, kindly
Can such and such is also can such and also stands disposed of accordingly.
Lordship will kindly observe, my lord, the other parts of the order, my lord, remains intact.
আচ্ছা একটা লাইন it is comma however made যেখানে reviewটা dispose of it is however made clear that the other portions of the order under review are not interfered with. Stop.
Grateful.
Content proceedings are dropped.
Grateful, Your Honor. Grateful, Lordship.
এবার তো স্যার
ওটা ফেরত দিন। ওনাকে
এখানে
অ্যাক্টের কপিটা যে দিল তাকে
না না
দিয়ে দেন